Did you know that victims can file papers in court to ensure that their voice is heard in criminal proceedings? Filing papers, which are called motions or pleadings, in connection with a criminal case can be a valuable tool for victims who want to assert or seek enforcement of their victims' rights. And while individual victims can represent themselves and file these papers on their own, which is known as proceeding pro se, the justice system can be confusing, so having a victim's rights attorney draft and file these papers on behalf of a victim is often the more effective practice. A common misperception exists that victims can't file papers in criminal cases because they aren't formal parties to the case. And while it is true that only the state and the defendant are parties in a criminal case, other individuals with rights and interests at stake in the proceeding may participate in criminal cases for limited purposes. For example, the media may file papers in a criminal case seeking access to the proceedings or otherwise asserting their rights. When an issue of privileged information is presented, such as a subpoena for medical or counseling records, it's long been recognized that a privilege holder can participate in criminal proceedings to protect the confidential nature of these communications. Like these other situations, when the rights of victims are at stake, they too can assert their rights by filing papers in court. Bottom line, a victim can assert his or her rights by filing papers in a criminal case anytime the victim's rights are at issue. Filing papers in a criminal case has several benefits. First, it helps put the court and the parties on notice that the victim is asserting his or her rights. Second, it's a vehicle by which a victim can be heard and participate in the criminal justice process. Third, filing papers can call upon the court to protect victims' rights, and by documenting these requests in writing, the victim's positions are preserved in case appellate review is needed to enforce the victim's rights. So what types of pleadings or papers might be filed to assert a victim's rights? A victim or a victim's attorney might file a number of different papers in connection with a criminal case. Here are just a few examples. A notice of appearance and assertion of rights is generally the first type of filing made by a victim's attorney. Victims can also file motions to quash a subpoena for a victim's private information, such as a diary or counseling records, motions to protect a victim's privacy, including motions to redact a victim's name from court documents or requests for the victim to be identified only by a pseudonym or initials, and motions for various trial accommodations, including alternative means of testimony, assistance of interpreters, the presence of support persons or facility dogs, or even the use of a comfort item. Victims can also file motions for restitution and sentencing memoranda. Papers seeking appellate review, including writs of mandamus and direct appeals, can be filed in appellate courts of all levels, including in state Supreme Courts and even before the United States Supreme Court. Amicus briefs can also be filed in support of victims' rights issues in both trial and appellate courts. Now you know a little bit more about victims' ability to file papers in court to assert and seek enforcement of their victims' rights. For more information, NCVLI has published a number of in-depth bulletins, including bulletins addressing victims' opposition to defense discovery requests and victim motions seeking release conditions or protective orders. These and others are available for download on our website in the Law Library. NCVLI can also provide more specific information and resources to members of the victims' rights community. To submit a request for assistance, please visit our website and fill out the online request form. Victims deserve to be treated fairly in the criminal justice system. NCVLI is here to help.